session. This is the Code Enforcement Special Magistrate meeting for the City of West Palm Beach. This is our other matters agenda. These cases are going to be heard in the order in which they appear on the agenda. If you hear your case being heard, go ahead and proceed to the podium on my right-hand side. The city will present the case first, and then you'll be given an opportunity to speak to me and present any evidence or information you'd like me to know. If you're asking for a lien reduction, what's important for you to tell me is what you're asking me for and the reasons why I should grant it to you. This is a quasi-judicial hearing, which means that the formal rules of evidence do not apply. However, all testimony is taken under oath under penalty of perjury. So if you're going to testify or you think you might testify or there's a possibility that you might testify, please rise and raise your right hand. Anyone that's going to talk at any point. Do you swear or affirm the testimony you're about to give will be truthful and accurate under penalty of perjury and the laws of the state of Florida? I do. All right, please be seated. City can call the first case.
Agenda item number, other matter number 1 and 3, case number CE 21020021 and case number CE 18040626, same address, 4149 North Haverhill Road, Unit 1607.
Go ahead.
Mitch Posner, Code Enforcement. Proceeding in chronological order, oldest case first. So case ending in 626, 4149 North Haverhill Road, number 1607. Date ordered 6/6 of 18. Fine started 6/18 of 18. Ran for 91 days, total $9,100. $100 a day. Date of compliance 9/17 of 18. Case ending in 021. Oh, correction. Same owner for both of these. Case ending in 021. Date ordered 3/3 of 21. Fine started 2/1 of 21. Ran for 30 days, total $6,200 a day. Date of compliance 3/3 of 21. 3 cases under the ownership. All were BTR cases. And the mitigation is twofold. The property manager caused the issue, and they had address issues, but this had nothing to do with the city sending notice, which was, of course, sent to the appropriate place. City's asking for 50% on both.
Sir, can you tell me your name?
My name is Jonathan, last name DiTullio.
I'm sorry, your last name was?
DiTullio.
DeTullio.
DeTullio.
And what is your relation to the owner, Lagoa LLC?
We are the property manager.
You're the manager for them?
Mm-hmm. Correct.
And do they know that you're here for them today?
Yes.
Magistrate, they did provide a designated agent form with his name on it.
Okay, perfect. So what are you asking me for, and why should I grant it to you?
Well, it looks like there is different cases there. I'm only aware of one. This is the most recent one for the $6,000. We only took over the property, the management of this property in 2018. And it looks like some of violations were prior to that, so we were not aware of those violations. And also, so we were not aware of all that, but as soon as we received the notice that there was an hearing here, I think it was on March 3rd, and we got notice on March 2nd, it was late at night, they called the office, I guess it was the registered agent office for the LLC, the owner. The next morning, we called the city and we pay right away. Whatever was due, we paid it. So on March 3rd, I'll say 9 o'clock or 10 o'clock in the morning, we paid whatever was due on the property. We've never received any notice because of the fact that there was a new management company. The address was not updated. And whoever was the previous manager never sent us the notice, let us know that there was a violation there.
Well, I think we can all agree that the previous managed company didn't do a particularly good job in relation to these particular issues. But what are you asking me for in this case?
Well, on our case, on the $6,000 to remove the $6,000 since we paid as soon as we knew. I mean, we paid before the actual hearing here. I think the hearing was at 2 o'clock in the afternoon on March 3rd.
By paid, you mean you obtained the rental license?
Yeah, we paid for it.
So they applied, they did not obtain it, still had to pass inspections.
Oh, okay.
I mean, for argument's sake, it's not a question of whether or not you obtained the rental license. I know you did, or at least you came into compliance somehow, or otherwise you couldn't be here today. The question is why is the fine that the city assessed against your property not appropriate, and why should I reduce it?
Yeah, I mean, we're, like I said, we took over the management and then no address change was made. I mean, nobody made the change of address. The registered agent, the owner, or the previous managing company didn't made any change of address. We have never got any notice that there was prior violations. Because it says here for our violation, it says it's a repeat violation. I mean, and we understand that we took over the management for this owner because the previous management wasn't doing their job. And
Yeah, I don't think anyone's casting dispersions on you, sir, or your company. The question is, this is a fine directed at the property owner. They rented property out without a license, and it went on for a while, and apparently it's happened more than once. So the city assessed a fine for them for $6,000 in this one case, and I guess the other one's a rental license case too as well, right? So
Yes, sir.
$9,000 there.
mhm.
I mean, the fact that you're a new company isn't really under the city code provisions on reasons to reduce the fine, none of those are legitimate reasons to reduce the fine, at least as I read the code section, 2639.
I understand,
I
but
mean,
I'm
you
saying
got to give me a.
I mean, we
you gotta give
complied.
me
I
a
mean,
reason.
as soon as we knew, we complied right away. I mean, if we would have known the day before, this would have been paid before the hearing. It's not like we tried to hide or we wasted time. Like I said, as soon as we heard about it, we paid.
All right. Well, what's the city's offer in this case?
The city is requesting 50%. In response to what he's saying, I certainly understand he acted quickly once he knew. But he said they took over the property in 2018, was unaware of the previous lien from 2018, and in 2021 was subsequently cited again for the expired BTR license. Granted, they acted quickly once they knew, but why didn't they know beforehand if they're the property manager and took over in 2018? And ultimately, it's not actually the property manager's responsibility. The lien is against the property owner, not the property manager, which is why we're here for 2 lien reductions, not just 1, because it doesn't matter when they started managing. But I would certainly think a property manager would make sure all the licensing is in place once they took over.
The city's offered to reduce it in half for no other reason than I guess that you came and asked, and I'm willing to do that, but you haven't given me any other reason. I mean, that seems fairly generous in light of where this case is and what you're, in fairness, I'm not casting any dispersions on you or your company. I'm sure you're doing the best that you can, but that seems reasonable in this particular case, and I'm willing to do that.
And that's for the total, right?
Right, for
both of
both
the-
cases.
Okay.
All
Thank
right,
you.
so I'm going to reduce the first case from 6,000 to 3,000. I can give you a time frame to pay this in. I could give you 30 days or 60 days?
60 days, yeah.
All
We
right,
have to
all right.
contact the owner and let him know.
All right.
Yeah.
All right, I'll reduce the first case from 6,000.
Magistrate, can we make it 90 just in case?
Yeah.
I don't want to come
All right,
back
we'll
with
make
it.
it 9.
Thank you.
Let's reduce the first case from 6,000 to 3,000, payable within 90 days, and we'll reduce the third case from 9,000 to we'll make it even here, $4,500, payable within 90 days.
Thank you.
Thank you for coming in, sir.
Agenda item number 2, case number CE 19080578, case address 949 34th Street.
Kristen, confirming that was 949 34th?
Yes.
Thank you.
Go ahead.
Case ending in 578 949 34th Street. Date ordered 9/18 of 19. Fine started 10/4 of 19. Ran for 412 days. Total is $41,200. $100 a day. Compliance date is 11/19 of 20. This is a new owner after a foreclosure did not cause the lien. The city's asking a standard 25%.
Sir, can you tell me your name, please?
Hi, good afternoon. My name is Amir Saeed. First name is spelled A-A-M-I-R. Last name is S-A-E-E-D and I'm an attorney for the owner, Federal and National Mortgage Association.
All right, sir, tell me what you're asking for and why I should grant it to you.
Your Honor, we're asking for a reduction totaling to $100. As this gentleman stated, Fannie Mae was the foreclosing plaintiff. It obtained title post foreclosure, and as soon as it could, it worked quickly to remedy these violations. But it actually was not responsible for causing these violations. It sort of just stepped into the place and fixed them as soon as it could. So for that reason, Your Honor, since my client didn't do any of the work that caused this damage, we'd ask for a much more significant reduction down to $100.
I recognize that your client did commit the violations. However, I mean, you did take the property with the violations on it. I mean, I'm not going to reduce it to 100. Can you make me a more reasonable offer?
Should we get a 50% reduction?
I'm sorry, how much?
A 50%?
The city's already offered to reduce
Sold.
it to 25%.
Well, the city offered 25% off of it, so we'd ask for additional 25%.
No, the city offered to reduce it to 25%.
Oh, okay, I'm sorry. I misunderstood you. Okay, Your Honor, we would
All
go
right.
with that figure. Thank you.
Anyone
I
got any
apologize.
math? What is that? My calculator.
Half of that would be 5,150.
So the city offered 25%, and you're asking me what?
And that's 25% of 41,000. I just want to make sure I understand. So
Yes, 21%, 25% of the 41,000.
So a 75% reduction. I'm okay
Yes.
with that.
Okay, are you good with that?
Yes, Your Honor.
And what kind of time frame?
Can we get 60 days?
You can. All right, let's reduce KCE 1908058. We're going to reduce it by 75%. Did anyone get their calculator out between now and then?
10,300,
10,300?
yes.
All right, reduce to 10,300 payable within 60 days.
Thank you.
Here's your order.
All right, moving right along.
Sorry, I'm not sure if I have somebody present for the next two cases. Was there somebody here?
I don't think 1106 8th Street is here.
Okay, I'll keep going then. Agenda item number 6, case number CE 19070325, and agenda item number 7, case number CE 20100016, same address, 924 37th Street.
Magistrate, can I have a brief moment to?
What's your name, sir?
Brian Ton, morning. I'm the owner.
One moment, sir.
Brian Tan. Hi, Mr. Tan, just hang on one second. We go wait for the code supervisor to come back. You're the owner of the next two, right?
I think the violations were for 924 37th Street.
Apologies, Magistrate.
Are these
I
two
think-
separate cases on the same property again? Yes. Okay. Sorry, go ahead.
Kristen, they are here for that other one. Okay, so chronological order, oldest case first, case ending in 325 924 37th Street. Date ordered 8/21 of 19, fine started 9/6 of 19, ran for 157 days, total is 15,700. $100 a day, date of compliance 2/10 of 20, same owner. Case ending in 016 924 37th Street. Date order 11/4 of 20, fine started 12/7 of 20, ran for 161 days. Total $32,200, $200 a day, date of compliance 5/17/21. Same owner, both cases, city is asking for 50%. Mitigation is they weren't aware, but service was proper. They had the wrong address listed with the county for the mailing address, which is no fault of the city if they didn't change that. Was served certified and, of course, posted to property at the time.
All right, Mr. Tan, the floor is yours. Tell me what you're asking me for and why I should grant it to you.
I'm requesting a reduction to 12 days times whatever the violation is. I think I had it on my application. But as was stated, I wasn't aware of the lien until I had new tenants in the property, and they gave me a letter on May 5th. And what I'd like to try to demonstrate for you is that within an expedient amount of time after knowing of the violations, that I was able to fix all of them. Some of them were already fixed even before the inspection. But I had some tenants that I had disputes with prior to this one, which I have reason to believe would withhold any communications to me and could have been actively working against me because they were delinquent on their rent. They almost got evicted. There were a lot of issues. Thankfully, they were able to leave on a non-renewal, and I had new tenants, and they received one of the later letters. I never received any of the previous ones. He delivered it to me, and by May
And why didn't you
17th,
get the notices that the city sent out?
sorry,
Why do you believe you didn't get the notices that the city sent out?
I just didn't have the mailing address listed as my primary residence. They were being delivered to the property.
Okay, go ahead, continue, please.
So I was notified by the tenant and delivered the letter on the 5th. And from the city's perspective, as of May 17th, which was the initial rental license inspection, everything was compliant. Right now, that wasn't the inspection for the lien reduction, but everything was already in compliance as verified by the city on that date. It was actually, most of those items were actually handled at different dates and time previously. And I have a timeline here, but there's multiple violations. But what I'm trying to show is that from the 5th to the 17th, at least from the time that I received notification that what is that? That's 12 days. So I'd like to, at minimum, be reduced to the 12 days times whatever per day violation it is. I acknowledge that it's no fault of the city that I didn't know to register for the license and have the address changed, but you know, if just to put it this way, if I had the tenants that I have in there right now in previously, they would have let me know as soon as I would have received any notice. And because of the speed that I was able to handle all of these issues, because some of them were handled already and the rest was after May 5th, the only thing that I really had to do was remove a stump and make sure that the tenant was parking his commercial vehicle in the backyard. That's really the only thing that had to be taken care of by then. Everything was already in compliance.
May I respond, Magistrate?
Absolutely.
Okay. I mean, we've seen a list of dates, but we've seen nothing presenting proof to the city that such and such was taken care of at such and such a date. It is always incumbent upon the owner of the property in violation to contact code enforcement and say, hey, this has been complied. Now, the earlier case was cited for tree abuse and address characters. They were some pretty simple things. The second case, I'm not even sure if he was aware of the older case since he said he didn't receive anything until 2020 from that new tenant. But the second case, in addition to the expired rental license, was for interior repairs, and apologies, but I'm going to give you a picture taken at the time, and we find it unconscionable to have even rented a unit in this condition. There's several more we could bring up on camera, but that's the gist of what was going on inside.
Now these repairs on the drywall that you see there, now that's the aftermath after there was some water damage incurred. Now the repair for the drywall and the recent renovation, that was completed as of February 4th, 2021. Now, the cause of all of that, and because, you know, that's just water damage. Really, the problem was a leak, a very small nuisance leak that lasted for a while, and I can show a history of us going through the roof, resealing windows, and a number of other things while we were trying to mitigate that. At the same time, I was going through the dispute with the tenants, which may or may not be relevant here, but I knew that the I knew that they would be out by February, and so I waited until they were gone so that we could get a crew in there and just so that they could have all their tools and everything to work in. But this is all during a period where I had no idea that I had a lien or that I was in violation with the city or anything. I think that the previous tenants were basically, I wouldn't be surprised if they were the ones that called in. Now, it's not that I would have done anything different, I just would have tried to patch that up before going in for a more comprehensive repair sooner if I knew that I was in violation or that I'd be subject to tens of thousands of dollars of fines. I'm just it's me and my wife, and I'm not a business or anything. I made a mistake in not knowing that I had to register and get the address corrected, but rest assured, all of this would have been taken care of much sooner, or in any means possible to avoid this. I feel that. What is the total amount between the two? Between the two violations or two lists?
It's
47.9.
37,000?
47.9.
$47,900. I mean, I feel that's, commensurate with someone who is willfully negligent. And I personally don't think that I have been willfully negligent. If I could show all the different services and everything that I've done, those pictures that you see there is the remnants after we had the water damage, while we were trying to mitigate it, and we cut it open on purpose to air it out.
All right, so the city has offered to reduce the fines by 50%, which would, if I do my math correctly, be $23,450. And you're asking for what, Mr. Tan?
12 days, whatever 12 days would work out.
Give me
to
a
be.
number. I don't need to go calculate.
so
What are you
12
asking
days-
me for?
12 days times $200 per day, $2,400.
For which one? What about the other case?
The other case, I believe, should have been resolved even before. Now, there's no proof to the city, but I think the other one was because of the commercial advertising, because he had his car parked in the street, and then there was a stump. There was another one for trash, and that might have been also when the other tenants were moving out.
So
They
the
might have-
$2,400 you're asking for in which one? Case 6 or case 7?
I'm asking for $2,400 for both, if it's $200 per day for either of them, because I was able to prove to the city from the date that I knew that I was notified of the lien on May 5th to the date.
I appreciate your issue of notice, but if it was an excuse that you weren't notified because you didn't put the correct address in, then everybody would put the wrong address in and then come back to me and tell me that they didn't get notice. So you understand why that in and of itself is really not a good or defensible argument to me, right? I mean, it's your
I do.
obligation as a property owner to make sure that they have the appropriate way to notice you through the property appraiser's office. So I can't penalize the city, nor can I discount your fine based on the fact that you made an error there.
Well, if it went for that tenant, I would still be unaware even right now, and the property would probably be in the same thing except for a stump. It's in compliance now. It's continued to be. Everything was as of the beginning of February. That property was in the condition that it is in from the most recent inspection, July 27th, I believe it was. It has not changed except for the stump. I have an invoice that can show that job was completed.
I'll tell you what I'm willing to do. Because I do believe that you're earnest, and I do believe that you're going to make a commitment to keep these properties in compliance with the code. I'm willing to reduce the first case, the $15,700, I'll reduce that to $3,000 payable within 90 days. And on the second case, which is $32,200, I'm willing to reduce that to $5,000 payable within 90 days. Is that enough time for you, Mr. Tan?
Yes, sir.
All right.
It was 30, is it 90 days or 30 days?
I'm giving you 90 days.
Okay, 90 days for both, okay, sorry.
Okay.
Thank you.
Thank you for coming in, sir.
Okay, agenda item number 4, case number CE 15040303, and agenda item number 5, case number CE 18010048, same address, 1106 18th Street.
Hello.
Cases in chronological order. Oldest case first, case ending in 303, 1106 18th Street. Date ordered 6/17 of 15, fine started 7/18 of 15, ran for 40 days, total 4,000. $100 a day, date of compliance 8/27 of 15, new owner. Case ending in 048, 1106 18th Street. Date ordered 3/7 of 18, fine started 3/14 of 18. Ran for 975 days, total was $97,500, $100 a day. Date of compliance 11/13 of 20, also new owner. Based on the fact that it is a new owner, city's asking for standard 25%. Only other relevant information is it is currently pending a sale for $240,000.
Ma'am, can you tell me your name, please?
Alina Benjure.
I'm sorry, one more time?
Alina Benjure.
I'm sorry, I'm not hearing you well.
Alina Benjure. Alina Benjure.
Alina Bedjere. And you're the current owner, ma'am?
No, I'm a representative for the owner, work for the property management company.
She is the designated agent.
Okay.
Correct, and excuse my ignorance, but I was hired recently and I was made aware of this yesterday, so I don't have much information, just as much as that the lien was there when they purchased the property.
Well, they really threw you into the fire, didn't they?
They sure did.
All right, so it looks like you have two cases where you have a fine of $4,000 and a fine of $97,500.
Okay,
And if I understood the city correctly, they were offering to reduce the fine by 75% in each case. So tell me what you're asking for and why I should grant it to you.
well, from my knowledge, the lien was there before the owner purchased the property. So I was just asked for the maximum allowable by the city. And I believe that he's done a lot of the improvements already. I've been to the property once, right before they rented it, and it's got new flooring, new paint, and he's done a lot of improvements there, and that's what I know regarding that property.
And what specifically are you asking me for, ma'am?
50% reduction?
Well, the city's already offered 75%, so
Okay,
they've offered more than that.
okay, great, so we're agreeable to that.
Okay. All right, so 25% of 4,000 is, so that would be what, 1,000 on the first case?
And 24,375 on the other.
What was it, 24 what?
24,375.
375. All right, ma'am, so what we would be doing here is we'd be reducing the first case from 4,000 to 1,000 and the second case from 97,500 to 24,375. Do you understand?
I understand.
Okay, is there a time frame that your client needs to pay this?
I would say that 90 days,
90 days?
correct.
Okay. All right, in case CE 150400303, I'll reduce the fine from 4,000 to 1,000 payable within 90 days. In case CE 180100048, I reduce the fine from 97,500 to 24,375 payable within 90 days.
Thank
you
you.
for coming in.
Yeah, can you spell your, Okay, agenda item number 8, case number CE 17090155, case address 7111 Norton Avenue.
Good afternoon.
Apologize ahead of time, Magistrate. This is going to be longer.
Okay. Then I'm glad it's the last one, so no one else has to sit through it but us.
This was actually originally, let me start with the case information. Case ending in 155 7111 Norton Avenue. Date ordered 11/1 of 17. Fine started 12/31/17, ran for 906 days. $226,500 is the total, $250 a day. Date of compliance 6/24 of 20 is the current owner. We've actually been here once before on June 2nd. At the time, there were 3 liens. The other 2 were against individual business owners at the same location. Mr. Grant basically sandbagged us. Instead of telling us ahead of time that there were issues they were questioning on the case, which is the purpose of this before we get here. He questioned 2 of the other 2 liens that we allowed them to present, even though they weren't the owner of those businesses. Regardless, subsequently to that, we said, okay, we'll pull it, we'll review those 2 things, at which point he began badgering the city to make a faster decision. By 7/12, the email we received was, there will be legal action against the city's magistrates via the Burt-Harris Act, which actually isn't even relevant in this case. So rather than continue this charade and wanting to make sure somebody experienced was going to be here for this lien reduction, we released the other 2 liens, and now we are here today. This lien has existed for the last 4 years. They're only trying to reduce it now because they are selling the property. Their attorney, Mr. Grant, has insisted we reduce it to $5,000 or they'll take other legal action. I'm hoping that just means this hearing. Regardless, it's $226,000, so the 50% we would ask is not going to be the case for obvious reasons. The city is willing to reduce this to 15.15%.
What would that total be?
I don't have that math in front of me, actually.
$33,975.
Thank you.
Okay. So,
Okay. Go ahead.
so I don't necessarily, I think the City of West Palm Beach staff, they did an amazing
Sir,
job.
would you please state your name for the record?
Stephen Grant, Esquire, on behalf of Esfander Babuti, who is the property owner standing next to me. There was a little false in the categorization of myself pestering or badgering. I thought 2 to 3 weeks was enough time for legal research regarding the issues. In addition, we have not received the lien release, so we thought it was for all 3 cases because we haven't received anything from the City of West Palm Beach stating that they're been removed.
The city has released the other 2 liens?
Would you like to answer?
I can check the public record.
They have been. The recordings aren't back from the county yet, but we can't present to you just 1 lease on city code. If the other 2 weren't released, we'd be discussing all 3.
So, I don't have that information. They said they were going to do it. However, they didn't provide us with any sort of public notice.
They made the assertion under oath that they've done so I'm going to presume that they have.
Okay. And may I please explain the reason why the lien reduction? It was not necessarily just because it was on the business owners. It was because the affidavit of noncompliance didn't have a notary stamp, which under, I think it's Florida Statute 117, requires it to be a valid affidavit. So that meant that the lien wasn't valid because the affidavit wasn't.
Well, for our purposes, those liens are gone, so there's nothing I can do with them anyway. So
Okay.
The only issue before me today is this particular lien for 226.5.
Okay, and so that's kind of where I'm sorry for the term I think you said was sandbagging you.
Could you repeat that, please?
Sandbagging?
At the last hearing, yes, sir.
Yeah.
Sandbagging.
Yeah.
I apologize for that because after reviewing the affidavit of noncompliance, it doesn't fit the timeline according to our notice of compliance. The affidavit of noncompliance for the case ending in 0155 is December 31st, 2017, where our notice of compliance was the day after, still within the time frame.
Well, that's
We
interesting. So
we don't have a notice of compliance that we issue, so I have to see what.
No, I didn't say
Referring to?
our notice of compliance to you to let you know that the property was ready for inspection. The the inspector on their affidavit said that they inspected the property on December 31st, 2017.
Okay, and the note from the case officer at the time on January 2nd, 2018 is failed violations remain.
But we have to go based upon the written document that was presented to the magistrate, which differs from what the case notes say. And so that's kind of where we have always offered the $5,000 because my client has always intended to make the property in compliance. However, after December 31st, 2017, or January 2nd, 2018, January 3rd, 2018, my client never received notice or correspondence or anything from the city of West Palm Beach that the property was still not in compliance. And so it wasn't until my client was updating his estate planning that we did a lien search on we did a record search and found the liens on his property. After which, we contacted the city of West Palm Beach. We made as much effort as we could to make the property in compliance as possible. After which, we had to deal with a little bit more issues with the city of West Palm Beach regarding expired permits, which, according to the city of West Palm Beach, were rectified after notifying them that another permit was applied and that expired permit was taken care of. In addition, there was a water utility bill that we paid as soon as we had notice. In addition, there was I believe, a police alarm fee that was for $650. And when asking for the invoice of all of the fees, it turned out to only be $125. So the city
Magistrate, the lien has nothing to do with alarm fees or expired permits.
I know, but
I'm trying to get to the fact that my client has always wanted to work with the city of West Palm Beach in an expedient manner. And that's kind of where we felt that we want to pay for the...
let's go back to the more central issue to this case, because I mean, if we wanted to sort of litigate your relationship with the city of West Palm Beach, we could all be here for some time. But the issue before us is this particular fine. Now, so you're saying that you brought this property into compliance in December of 2017?
So, according to my client, he said we painted the strips, we covered it with sod, we did everything that we needed to do to bring the property in compliance, and according to the magistrate's notice, we could send a fax before January 2nd to note that that property is in compliance, and that is what we did. And after that, there was nothing that was heard, or there was no correspondence with the city of West Palm Beach and myself as letting them know as an agent of the property owner or to the property owner that other inspections have occurred and the property was found in compliance, that a lien was put on it. So
your argument is that once your client sends in a fax saying I'm in compliance, then they have no further responsibility.
No. We absolutely have responsibility to make sure that the property is compliant. However, if we didn't follow up with the city of West Palm Beach to know that it was in compliance, we would have, this is the situation. We didn't follow up to say, hey, you received
I mean, typically the way this works is that when you let the city know you're in compliance, the city sends out an inspector, and the inspector either says you are or you're not.
And that's kind of what we didn't hear from the city inspector to know that we weren't in compliance. That affidavit that was signed on January 3rd.
I mean, typically the person who has the violation on their property speaks with the inspector and says, "Did you find me in compliance?" Right? I mean, was your client not curious about what that the city was just going to accept their facts?
And that's kind of it. Is that the two businesses that were tenants there that have the same violations were under the impression that they were in compliance, and fast forward, those affidavits of compliances and those liens were not proper, according to the city's attorneys, and that's why they're dropping the case. So
those aren't before us.
Well, they were last time, and so that's kind of where
so
we filed.
The city has already conceded whatever argument they're going to concede on that. They've dropped those. The only one I'm focused on is the one we have here today.
Okay, and so I'm trying to say that this is not the only time the city has made mistakes. And so that's
I'm
kind
sure
of where,
the city makes mistakes all the time, as do many municipalities. But the question today is whether or not this lien is, because you're making an argument, I presume here, that this lien is improper.
well, there is that argument too, but my client would rather pay the $5,000 to be over and done with it rather than try to argue the legal matters of this.
Let me let the city respond to your argument, if either the city attorney or the supervisor wants to respond to this.
First, the city did not actually concede anything where the other two liens are concerned, but I know you don't want to hear about those. We simply dismissed them to proceed with this. The crux of the matter on the case was pretty much that it's a car repair business at this property. In operating their car repair business, they had cars just about everywhere. Code actually prescribes how many cars you can have there, how many cars you can be working on, and you certainly can't keep them in the street. Now, they're saying they complied this in December of 17, which we did not agree with. Furthermore, I've got a picture here from May of 2018, October of 2019, and then June of 2020. The June of 2020 is the one that shows compliance. I'll let you judge the difference for yourself.
That's not our property. Those pictures that were on the screen. Yeah.
This is not the property in question, sir?
No, the pictures that they had on the screen that we were looking at. But no, these are pictures of the property. Absolutely. It is a business providing economic activity to the city of West Palm Beach. They do not necessarily, and as you can see, they have the white markers so that people are not parking on the sod as required, so to help maintain the sod. The fact that they are a car repair, they are allowed to have, inoperable vehicles on their property because the fact that they repair vehicles, some of them come in inoperable. The fact that one of the tenants didn't realize they needed to get a storage license, BTR, to be able to store the vehicles for more than an extended period of time, which they obtained this past May. I believe it was Los Amigos. So we understand that the tenants who are running a business had vehicles there because that's their business. And we didn't realize that was against the city's code to run a business. Because the property owner...
I'm pretty sure that's not against the city's code.
No, according to the city's code, they said that they left inoperable vehicles there for too long without a specific BTR. And after some due diligence, we realized once we get that BTR, we're able to store inoperable vehicles for an extended period of time. So it's kind of the fact that there are different departments within the city that...
it's a big city.
Yeah, that the planning and zoning and the code compliance, they said, well, you need to be in compliance in this. However, they don't necessarily always tell us the most efficient and effective manner to become in compliance.
I want to go back. To me, it seems to me that the chief issue here, there's a lot of other things going on here in the background, but the chief issue here is whether or not your client is responsible for the compliance date that the city is giving you versus the one that you're going for, based on the fact that your client said that they were in compliance in December of 2017, because that seems to me the crux of your case, right? That's the argument you're making, that your client believes that they were in compliance and that the city has an obligation to affirmatively tell them again that they're not in compliance, I think is the argument you're making, right?
That is one of the key arguments, because what ended up happening this past year is that after our first inspection, the property wasn't in compliance, and they gave us 45 days notice to have the property re-inspected. Within those 45 days, we requested to see what else, to have the property inspected, and if there was anything else needed, with an email to Ms. Williams. That email was forwarded to Mr. Posner, and he gave us an additional 30 days, I believe in April of this past year, to come in compliance. So what happened in 2018 almost happened again in 2020, but because the code compliance officer notified us that we failed the inspection, we were able to rectify that in the correct, in a manner of time, because we have always tried to work with the city. But if we talk to the city and they don't talk back to us, we're not able to understand the city's position.
So you're making the argument that the city has an affirmative obligation to let you know that you are still not in compliance. All right, how does the city respond to that
For
argument?
starters, I'm not sure where that appears in Chapter 162. I don't believe it's in there anywhere in my experience. But there is no legal requirement to have done so. I would certainly urge an officer to communicate better, but I can't go back in time and see what communication took place then. They're saying they notified the city that it was complied, but I don't see their picture showing it was complied either. Bottom line is we're sitting here trying to go back in time and argue compliance when all I've got is the documents and the notes in the case. I haven't really seen much from them. They may have sent an email and even provided it. And I'll say, yep, you sent this email. But I don't see anything that shows it was in compliance at such and such a date. Whereas I know past that date, it was definitely not in compliance.
Now, typically, when the city finds a property in compliance, they issue a document saying, or do they don't issue a
There
document?
is no actual compliance document. If somebody asks for one, I will happily send them an email on letterhead saying, hey, you are in compliance.
And if a property is not in compliance, the city will check on it periodically, and, if it comes into compliance, they might note it, or,
There's not even a periodic check. If the property comes to our attention, we'll certainly look at it. If the owner calls up and says, hey, this is still accruing, we'll look at it then. Anytime somebody asks for a compliance inspection, the city will do one. We're certainly duty-bound to do that when they have a fine running, as opposed to just ignoring the request. But just requesting a compliance inspection doesn't mean somebody's in compliance. There were other dates in the history of this case where they requested compliance inspections. That's why you have pictures from other dates, and it's still not in compliance. 10 and 24 of 19,
So
property
subsequent-
inspection requested,
Just so-
failed violations
so I
remain.
understand. So subsequent to December 31st, 2017, the city has record of them requesting additional compliance checks.
Yes. It was requested in October of 2019.
So if your client was requesting additional checks to see if they're in compliance, then why did your client believe they were in compliance prior to that?
Because, so we sent the notice on October 1st, 2018. After researching the official records, we noticed that the city put a lien on the property in October of 2019.
Okay, so you
And so
had
we had
noticed
no
that the city had
notice
liened the
or
property.
correspondence, unless the city of West Palm Beach has difference, of our October 1st, 2018 notice that we thought we were in compliance from that date when we researched the official records and got constructive knowledge that we weren't in compliance. So it goes to that actual notice that we're saying we wish we had that ability to fix that issue as soon as we could, because we would not have waited until October of 2019 to start this process, which has taken a very lengthy time. It wasn't until June of 2020 to become in compliance because of all the things that we did not know that the city required, because originally they said you needed to repaint the stripes on the parking, and my client did that. And then they said, no, you did it incorrectly because we didn't tell you that you needed to get a permit in order to paint the stripes. Because they thought that if they just repainted the stripes as is, that would be in compliance.
City cannot be responsible for their assumptions that they could just do it that way. All work on property should be checked for what permitting might be required.
Yeah, this is an interestingly complicated one for me, because to some degree, I do think the question of compliance is a pivotal one in this particular case. I don't know that I'm satisfied that sending a note to the city saying that we believe we're in compliance is in and of itself sufficient, nor am I aware of any obligation that the city has under Chapter 162 necessarily to send out another notice after they've done it. It's sort of an affirmative obligation at that point of your client to make sure that they have complied with the requirements of the magistrate order. So I don't know that I'm terribly satisfied with that as an argument.
I understand what you're saying, and it's to that point where the officer may say one thing to the tenant and write something else, because as the code, as Mr. Posner stated, he doesn't oversee everything that is said by all of his inspectors.
Special magistrate, I need to object to that kind of testimony, alleging that the city writes something different than what they discussed with the tenant. Is just an allegation without support. The city endeavors to always accurately, as reasonably as possible, to document their file. They don't make it any type of a practice to try to write something different than what was discussed or
Yeah,
told to
that's
them.
fair. Let's not,
And so
I'm not going to
the-
presume any
the-
malfeasance on anyone's behalf.
So that goes to the point where there was no pictures taken at that time, because the pictures were taken 4 or 5 months later. So that's kind of where I have that credence that the city normally takes pictures when they do inspections, and at that time, they did not take pictures. So.
All right, so I mean, I do think there are some equities on your side. But I don't know that, I don't agree that it is such that a $226,000 fine gets reduced to $5,000. I don't see that in the evidence that's been presented to me. So the city has offered, what was the city's offer?
Reduce it to 15%, which is 32,975.
So the city has offered to reduce it
33.
33,975. Thank you.
33,979. All right, and you have offered 5,000. Is that correct? Did I get that right from
That
everybody?
is correct.
All right, this is what I'm willing to do. So the city's basically at 34. I'll reduce the city's offer to 17,000, payable within 60 days.
How many days was that, sir?
60 days.
You can file a loan on the property, but can you make, what payments can you make per month? Yeah, can you do 2? I'm aware.
Under Norton Avenue.
So my client is saying, trying to get a stipulation agreement. I've requested that he'd be able to pay the $2,000 a month for that amount, so that would be.
Typically, we don't do that. I can give you more time if you need it, but I can't, there's
Okay.
no payment plan.
So that's kind of where, my client would
If
request.
my
the-
math is correct, that would be 9 months, and we're certainly okay with giving them 9 months to pay it.
I'll give you the 9 months.
Okay. I think so. Thank you.
All right, so payable within 9 months.
17,000.
I think that's it, right? All right, no
So
further business
concludes
before
my
us.
final hour.
This meeting is hereby adjourned.
You know what it was?